Welcome back to the Legal Alternative Podcast. Me, Sam Pawson, joined us by Nils. Nils, we're back.
20th of January, and we're back.
Yeah, it's been a long break. We've moved. The viewers will see. We are temporarily in another room in Dock Street. So still in Dock Street, but yeah, while original podcast room's being refurbished. So we'll be moving back, but yeah, back in where it actually began, Nils, when we had an audio only version. In the studio. So it's good to be back. Lots to discuss. A few updates. I think you're going first, quicker one, and I've got something quite complicated, so I'll let you go first.
Yes. So it's cropped up this week about illegal working.
Yeah.
And it's not a pleasant place to be if you unfortunate enough to find yourself either being accused of that by the authorities or stumbling into that.
Yeah.
So I'm obviously not going to name the case or which would be unfair. What I did want to talk about was something that I thought would make it easier for employers, which is the mandatory digital ID that workers would need to sign up to prove their right to work in the UK. I thought that would make it quite a bit easier for employers. Anyway, that's been dropped. So the government's dropped that plan to require workers to sign up to that mandatory digital ID. They've said the scheme will now deal less narrowly with immigration, and the government will place more emphasis on digital ID being a useful tool for the public when accessing public services. I must admit, I haven't looked into what those public services might be, but it's not going to be as broad as perhaps employers would like. So other forms of ID will be allowed instead, such as biometric passports with a digital chip, e-visas, which we've discussed in the past, and checks will move fully online by 2029. So still some way off, replacing the current paper-based system. So something that I thought would be, I don't know why it's been dropped. The government here, and I'm not getting political, the government and Keir Starmer denied that the change represents a policy U-turn. So the key point of the checks to show a digital form of ID is still there. So it was only announced in September, actually, and then by January, it's been dropped. So I think that personally would have strengthened the ability for employers to check. It would have been something that probably did deter illegal working. I suspect if you're really that determined, you're going to find a way to do it. But I thought that was something that was quite a good thing. But sadly, it's not going to be a tool that's going to be in an employer's arsenal.
Yeah, nothing hugely to add from my point. I'd say, we can get into politicals on the digital ID and why it's been dropped. As you say, it seems any sensible move forward to automation, to digitalisation would seem to cut down all the problems we've talked about in the past. Yeah, it's something that's not coming in, but right to work check's still a big issue. That we deal with all the time.
Yeah.
So it's that we haven't got this added digitalisation, but still obviously critical so that you get it right.
Yeah, exactly. Yeah.
Fantastic. Right, I've got a bit more of a complicated one. I think, Nils, when we last spoke, we're obviously in the midst of more Employment Rights Act change. And I think, over the next month or so on the podcast, that will continue at pace. While we've got a bit of a gap before April, the first few changes that are coming in, I thought I'd focus on a quite complex but really critical disability case where we actually involve an employee who has potentially harassed another employee through misgendering them, but then has brought their own disability discrimination case. So let me talk you through. The facts are quite complicated, but then the actual findings I think can be really applicable to all cases, even though the facts of the case are quite specific. Involves an employee who worked at the University of Manchester, who was employed as a learning technologist. Employee in question was a Karen Sylvester, and she had dyspraxia, diagnosed with dyspraxia. Dyspraxia, generally a physical condition, but there are associated issues with how your brain processes information. There was a number of incidents at work where the claimant in this case has misgendered an fellow employee at the University of Manchester. In the case, it's CD, always abbreviated to initials, who was a transgender employee. And there was an issue of the claimant misgendering her and using the incorrect pronouns.
Okay.
This was done on a number of occasions, but critical instance when it was done publicly in front of a number of employees. Investigation followed. Claimant was sanctioned, not permitted to work in the same office as the other employee, couldn't interact with the rest of the team, and isolated on campus. That resulted in the claimant going off sick. The claimant did return to work, but has been moved into another role, continues to be employed by the university. Then brings a claim in disability discrimination in connection with the change of role and being isolated. Evidence relied on is that the university themselves has failed to make adjustments in connection with her disability being dyspraxia, that it would take her longer to process the change in pronouns, which the university didn't take into account when subject to disciplinaries based on, obviously, the university's view that they had harassed an employee by misgendering them. Reaches the tribunal on the basis of that claim, as I say, disability discrimination, but no dismissal. Employee stays in employment. Tribunal found, and I'll go through the findings in some detail. The tribunal found in favour of the claimant and said the incorrect use of pronouns was because of her dyspraxia, and that condition meant it took longer for her to consistently adopt the correct pronouns compared to a neurotypical person, the dyspraxia having an impact on the short-term memory and language process. So they found that was the reason, obviously, for the misuse of pronouns, as opposed to someone who would have been able to pick up the change quicker. The specific finding in terms of when we talk about discrimination, is that the tribunal accepted that the university had a legitimate aim of maintaining a harassment-free workplace, but found that the approach by isolating the claimant from her colleagues, ultimately removing her from that role, was not a proportionate means of achieving that a legitimate aim, and they failed to make reasonable adjustments in doing so. So that claim was found in the claimant's favour. We've not yet had a remedy hearing, so there's just a finding of liability, no finding yet on remedy. What I thought it'd be a useful case to highlight is, again, these cases where you've got competing protected characteristics and you've got harassment potential claims across, but actually the perpetrator of that harassment themselves has a disability. The key takeaway from the case is about that proportionate means. So when we're talking about indirect discrimination, when we're talking about reasonable adjustment cases, you're looking at both, well, what is the aim that the university in this case are trying to achieve, but what's that means of achieving that aim? And that's where the university have fallen down on this case. Yes, they need and they should look for that harassment-free workplace, but actually what they've done to the claimant is that proportion. So by completely isolating them, by obviously from her other colleagues, not just the claimant, that's had a real detrimental effect on the claimant. So what other avenues could they have looked at? So they've seemed to have gone quite quickly to a complete isolation. Is there any form of mediation being looked at? Is there any form of training? Is there any form of further discourse with the employee who has been harassed to understand the claimant's condition? And look at that adjustment. So this again is relatively common that we see in practice, and I do have sympathy with respondents and companies that they are so concerned of pursuing what they seem is the requirement of the law. So we've got lots at the moment in terms of harassment-free workplaces, sexual harassment or otherwise, and they go so far to make sure that they are complying with one piece of legislation, they actually neglect another piece. So and I do have sympathy for employers there. It's difficult that you're having to have competing authorities, but it is actually something I think if you look at this rationally and independently, that you probably would see in any, I think a prudent investigation would see that, you know, you are being far too onerous by completely isolating this individual, and actually look at those other options, look at that kind of mediation. So we often think of mediation as something that's done alongside a claim, but actually mediating an issue between two employees is something that, you know, can be really valuable. Sometimes it's not appropriate. You know, in lots of harassment cases, it might not be, but this is something that's clearly connected to a disability, and you would hope that there would be an avenue through that. You know, I thought an interesting case to bring that kind of dichotomy of the challenges organisations have, but actually look at this rationally. I think there was an avenue.
Yeah.
Don't know any views for you.
Yeah, I mean, I've not read or seen that case before, but as you were speaking there, my immediate mind went to is this punishment within the band of reasonable responses? This is not to criticise the university, but I would expect that type of punishment almost to be what you'd have got at school. It's gone quite extreme, and it hasn't really the university clearly hasn't sat down and thought about the balancing act that there needs to do. So I'm quite surprised. Not in 15 years have I come across, I don't think, anyone ever asking me, can I isolate this person? And I don't think I've ever come across that.
I think they've obviously, rightly or wrongly, and we'd say wrongly, they've you know, when they're weighing at risk claims, I think they've probably been so concerned about, obviously discrimination based on that gender reassignment, that has caused them probably to lose a bit of perspective. Yeah. And it's, well, how do we mitigate risk of this person claiming, has resulted in them going, you know,
too far.
It's that balancing of risk and understanding in claims. There can be two risks. We've talked about that previously, and it's something I do in practice a lot of time. When there is instance between two employees, you might be there might be a primary risk, but there's that secondary risk that you also need to kind of consider.
I suppose as well, that type of consequence is not going to really mitigate against a claim anyway, is it? The potential claim has already happened. So by going to that extreme and saying, well, look what we've done, that's not necessarily going to have a huge effect anyway, isn't it?
No.
So it's quite surprising, really.
It is, but it's, as you say, without being involved in the advice, it's difficult to understand what steps. I think this is a reaction.
Yeah. That's
slightly misguided. But interesting case.
Very, yeah.
So back on the podcast, out of the office, we'll be seeing each other. We're back on the seminar trail, back on we've got some exciting new partnerships as well.
Absolutely. So Halifax Panthers, we're now proudly on their sleeve. Another feather in our cap, really. Good set of people, been working closely with them the last couple of months. So really pleased that we've been able to get a more formal partnership with them. And we've got, as part of our package with them, sponsoring the business club. Yeah. Next month, really looking forward to both of us talking there at the Halifax Panthers Business Club about what it's like to be a sports lawyer, basically, the type of cases we deal with and how it all unfolds. So looking forward to that.
It should be a good one. Out of series of seminars back on the road. Details, as always, on the Chadwick Lawrence website will be released as part of the Monday Morning Dispatch. So obviously any listeners have all the information there. It'll be good to get back out, good to start speaking and get back to the podcast. So I think we'll be back on our usual weekly podcasts from now on. As I say, from my point, lots coming up. Employment Rights Act before April and onwards. So regular updates from me in terms of legislative changes, some of the quite big ones coming in, 6 months now, obviously unfair dismissal coming in from January. So I think we'll both spend a lot of time on the podcast discussing that and impact for employers. So as always, updates will keep coming. Anything you want us to talk about on the podcast, let us know. Happy to do that. And it's been great to be back. Yeah. So it's goodbye for me.
And for me.